Good morning, everyone. I want to get things started now so we can respect everyone's time. I would like to start today with a land acknowledgement. We are, of course, gathering virtually today, so I hope you'll take a minute and reflect on the history of the lands that you're on. As a professor at York University, however, I'd like to read the university's land acknowledgement. York University recognizes that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located that precede the establishment of York University. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Takaranto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. Thank you. With that, I'd like to welcome everyone and thank you all for attending today. A big thank you as well to our speakers and our moderators and our sponsors. I imagine if Zoom has taught me anything, people will be trickling in over the next 10, 15 minutes as they get out of bed and get their kids to school and find the time to turn on Zoom again. So my name is Ian Stedman. I am an assistant professor in the School of Public Policy and Administration at York University. My own research has been primarily focused on parliamentary ethics, but more and more I've come to realize that I've been missing out on a very rich dialogue about political accountability that is taking place at the municipal level. So that being said, I'm sure you all know that the Ontario government has launched a consultation on municipal codes of conduct. Today's event is an opportunity for us to learn from one another, but also to acknowledge, I think, the importance of participating in consultations like this one. So what I'd like to do to get us started is I'd like to take a few minutes to provide a brief introduction to the consultation and what it is about. Very brief, don't expect much here, just kind of lay of the land. So way back in December 2020, it seems like way back, doesn't it? The Association of Municipalities of Ontario, the AMO, had a meeting with Ontario's Minister of Municipal Affairs, Steve Clark. This meeting was what was known as an MOU meeting because the AMO has a memorandum of understanding with the province that allows the AMO to provide the province with pre-public consultation input about any policy ideas that the province is working on in the municipal space. So the goal is for the province to be better informed in its policymaking processes. You can find more information about the MOU meetings on the AMO website. They actually post minutes and everything. So in that meeting last December, Minister Clark asked the AMO for input about the potential for a councillor recall mechanism. For those who don't know, recall effectively means having the ability to remove an elected official from their public office. So the AMO president, Graydon Smith, he replied to Minister Clark on February 3rd of this year, 2021. I'm going to post for those of you who don't have this, the link. Oh, you can't post it. Garrett, maybe you can post that later. The big takeaway from the AMO's letter is that its board did not support either of two ideas that were proposed by the Minister of Municipal Affairs and Housing. So the first one was that a council member might be able to be removed by the Minister of Municipal Affairs and Housing. The AMO didn't like that. And the second one was that a council member might be able to be removed, or sorry, might be able to be recalled by a vote by voters, right? They could recall a councillor. So the AMO said that these options, quote, did not meet the principles of respect for municipal government institutions and voters. The letter provided some other ideas to ensure greater accountability, including suggestions about code of conduct enforcement, disciplinary measures like suspensions and administrative monetary penalties, which many of you might call fines, but they're technically not fines, AMPs, AMPs. You'll hear that throughout the day, I'm sure. And the need to provide more education for councillors about how they should behave. The government listened and has launched this public consultation that anyone can respond to, and we will make sure the link goes up again for those of you who are interested in checking it out. And there are really only four major questions being asked here by the government. The first is, what kinds of rules should municipal codes of conduct include? Second is, what kinds of penalties would help to strengthen accountability? And relatedly, when should those penalties apply? And finally, they're looking for suggestions on how codes of conduct could be better enforced. The consultation website does allow free form answers. So there's this block, you just fill in your answer. My hope is that everyone in attendance today will consider going on, reading, making a submission if they feel comfortable doing so. Because I think these are important questions deserving of our attention. And honestly, they're deserving of our sustained engagement, even well after today's session. So with that background, which I hope is helpful for those of you coming into this and who aren't of the municipal space, I'd like to introduce my co-host, Professor Chris McDonald. Professor Chris McDonald is an associate professor at the Ted Rogers School of Management at Ryerson University and the director of the Ted Rogers Leadership Center. He's also a co-founder of Choice Point Solutions, which a company that I'm sure you noticed is a co-sponsor for today's event. So over to you, Chris.
Thanks very much, Ian. And I'm just gonna, my own part in this is very brief. I just want to welcome you all. Thank you all so much for attending. This is, I think, a very, very promising event, and I'm looking forward to hearing what you all have to say today. My main job this morning is to introduce you to a couple of very special speakers who are going to speak relatively briefly at the beginning before we start our main program. The first is, and I'm going to do a screen share here because he's with us by video, and I'll just share my screen and then I'll introduce him. Justice Lawrence Sawson was appointed to the Court of Appeal for Ontario in November 2020. Before his appointment, Justice Sawson served as Dean of Osgoode Hall Law School at York University. And previously, Justice Sawson was the Integrity Commissioner for the City of Toronto. And here he is.
Good morning. For those who don't know me, I'm Lawrence Sawson, a judge of the Court of Appeal for Ontario, and a long time member of the municipal accountability community. I'm delighted to have been asked by Ian Stedman to join in the welcoming remarks this morning, and I commend him and others involved in organizing today for putting together what is such a terrific array of speakers and no doubt lively discussions and insights to come on the municipal codes of conduct. It's an area that continues to engage and perplex and intrigue me, both as someone who was an academic in this area and someone who had a chance to interpret, apply a code of conduct in the City of Toronto setting and explore the accountability relationships arising from it. I know that this is an area that we're all revisiting and coming to fresh in the this process, and I hope from that set of discussions, again, valuable paths forward emerge, and I will look forward to keeping track of those, and again, wish I were there live in person to share in the discussions, but I have no doubt that they will create positive ripple effects, and I wish you the very best for successful and eventful day. And again, very much I wanted to express my gratitude for being included, and look forward to seeing all of you soon in person, hopefully when circumstances permit. Thank you very much, and all the best.
Okay, thank you very much in absentia, Justice Sawson. Next, it's my great pleasure to introduce the Honorable J. David Wake. David Wake is now serving his second term as the Integrity Commissioner of Ontario. Commissioner Wake was previously Associate Chief Justice of the Ontario Court of Justice from 1999 to 2005. Take it away, Commissioner Wake.
All right. Yeah, I did a few other things along the way as well, but nobody wants to hear all of that. Thank you, Ian, for inviting me to this symposium on municipal codes of conduct. I see that you've rounded up all the usual suspects. This is the third time this month that Jonathan Batty and I have delivered remarks at gatherings in which municipal integrity matters have found at least part of the program. Last week, the public sector ethics program, which the conference which we put on, which was attended by over 300 people from across the country, had a significant municipal integrity content. I see Suzanne Craig is on today's program, as she was last week at the Public Sector Ethics Conference. A lot of the interest in municipal integrity issues, I believe, stems from the recent Collingwood judicial inquiry and the recommendations in Associate Chief Justice, as he then was, Morocco's report. I was pleased to have been invited to appear at the inquiry to provide an outline of how our code works, our code being the Members Integrity Act itself. The two pillars of that act, which can be adapted to municipal codes, are the requirement for all members to make full financial disclosure to the Integrity Commissioner, and the requirement to meet with the Integrity Commissioner to discuss that disclosure in particular, and their ethical obligations under the Act in general. I told the inquiry that there is a side benefit. MPPs who were initially reluctant to have to come and meet with me, whether because they didn't want to disclose their finances or whatever problems they were having, but they were there because they were obliged to be there by statute, have opened the lines of communications with me. Many have found that it wasn't as bad as a trip to the dentist, and they've actually come to enjoy the experience and feel much more comfortable about picking up the phone and calling me when something happens. I think some have me on speed dial, and these are people who were initially reluctant to come had it not been for the requirement in the Act. I was pleased that Associate Chief Justice Morocco agreed with me and put it into his recommendations. In fact, it's recommendation number 62. The Integrity Commissioner should meet with each council member on an annual basis, which reflects what occurs provincially. Now, I'm not going to get a swelled head about my contribution to the recommendations of the Collingwood Judicial Inquiry, because that was number 62 of 306. So there's a lot of other stuff in there that can inform the discussion today and the discussions that will take place as part of the consultations that the government is setting up. So I unfortunately have to go to a meeting for a little while, but because the program is so interesting, I'm hoping to be able to jump back in a half an hour or so after that meeting is over, and I look forward to hearing the rest of the program and wish you all the success. Thanks a lot for inviting me.
Thank you, Commissioner Wake, and thank you, Justice Sawson. It's a pleasure to have you both here asynchronously and synchronously, as we're all getting used to. So before I hand things over for the first panel, let me cover some quick housekeeping matters. Garrett McSweeney, whose mug you should see up here somewhere, will be monitoring the chat throughout the symposium. So if you want to post a question, just send a direct message to Garrett, and then he will assemble and collate all the questions for when we have a discussion period. We also invite you to please make your screen name accurate so we know who's asking questions, and we can all do a little bit of virtual networking in some ways, at least get to see people. And at the bottom of your Zoom screen, there's an option for captions if you'd like to caption what's being said today. Okay. So with that, I would like to introduce you to Hilary Martin. Hilary Martin is chairing our first group of speakers. She's a co-founder and principal of Choice Point Solutions, and she's a strategic planning consultant and a trained coach. Hillary holds an MA in philosophy from York University and has completed training with the American Evaluation Association, the Darden School of Business, and most recently, the Ontario Institute of Studies in Education, OISE, for those of you who know U of T. Training on the design, facilitation, and evaluation of adult learning and development programs targeting workplace learning. So thank you. Over to you, Hillary.
Okay, thanks so much, Ian. I'm Hillary. I'll be moderating the first session, and it's on where are we now, what works and what doesn't work. So this will be the structure. Each panelist will speak for 10 to 15 minutes tops, and we'll have 4 panelists in the first session. We'll hear from them in turn. Then we'll move to questions from attendees. To keep things moving, I will signal when we're at 10 minutes. And panelists, what I'll do is I will raise my hand and I'll pop up in your gallery. So that's your indication. If we were in person, I would be holding up like a card that says 10 minutes. And participants, remember to send your questions to Garrett in the chat. So quickly, our 4 panelists are Robert Swayze. Robert Swayze is the Integrity Commissioner for a number of municipalities across the province, including the Township of Erin. Swayze is also a lawyer and has served as Integrity Commissioner for a number of years in a number of municipalities. Second, we'll have Melinda Monroe. Melinda Monroe is the Integrity Commissioner for the County of Brant. Alongside her role, Monroe is also a lawyer, facilitator, and consultant, heading up Monroe Strategic Perspectives. Then we have Suzanne Craig. Suzanne Craig is the Integrity Commissioner and Lobbyist Registrar for the City of Vaughan, and also serves as the Integrity Commissioner for the Muskoka District Council. Craig was also a lawyer in Italy and a forensic investigator in the European banking sector. And finally, we have Jonathan Batty. Jonathan Batty is the Integrity Commissioner for the City of Toronto. Batty is also a lawyer, and prior to his appointment was the Associate Chair in the License Appeal Tribunal and the Human Rights Tribunal of Ontario. So starting us off is Robert Swayze. So over to you.
Thank you, Hillary. Can everyone hear me okay? Good morning, and thank you for being here. Just a little bit on my background. I've been a lawyer specializing in municipal law for more years than I care to admit. I was in Toronto for the most part. My most prominent client was the CN Tower at that time. That's a long time ago. My first appointment, I then left private practice and joined 2 municipalities for 12 years as city solicitor and as Commissioner of Corporate Services. My first appointment as Integrity Commissioner was Oakville in 2008. Since then, I served as Integrity Commissioner for 59 municipalities. I counted them yesterday. That's over the past 13 years. This is all I do now, and I do not practice law. I'm going first, not because I'm the oldest, but because I have a viewpoint that many of my colleagues may disagree with. I am of the opinion that almost no changes need to be made to the Integrity Commissioner regime at this time. I'm sure my colleagues will have differences. So let's start with my position on the issues raised by the consultation by the province and the letter from AMO. I don't agree with integrity commissioners having the power to recommend removal of an elected councillor from council for any code of conduct violation, or even going to court for that. 90 days pay suspension is enough. I also don't agree with voting for or recommending or even the minister recalling a member of council. It's too much. Only a court should be empowered to do that. Next, I don't agree with standardizing codes or the Integrity Commissioner procedure. It's adequately covered in the Municipal Act and the Municipal Conflict of Interest Act. I ask, what is wrong with the existing codes of conduct, which have been developed by professionals and supported by councils across the province? They work and they can be customized at any time. The participation by council and staff in choosing an integrity commissioner, those RFPs that some of us enter into, and the creation of their own code of conduct has been embraced generally by both council and staff. This should not be changed. A standard code of conduct for some provincial accreditation for integrity commissioners would be a mistake. The buy-in by councillors and staff would suffer. Another question that's being asked is there a problem with councillors harassing staff, members of the public or each other? I say it happens, but the integrity commissioner has adequate authority to deal with it, either a reprimand or a maximum of 90-day suspension of salary. When that was created, I don't know who created it, but I thought it was brilliant. It's the perfect amount as far as I'm concerned, and it was almost prophetic. And I go back to 2017 when the province started its consideration and relook leading to Bill 86. I was gratified with the result. We all had input at that time. I was concerned about having a mandatory indemnity because I was being sued by the mayor of Brampton at that time, and it was included. I felt that Bill 86 was an endorsement by the province of all we were doing as integrity commissioners. Our authority was expanded under the Municipal Conflict of Interest Act. We were empowered to go to court for a pecuniary conflict of interest, which was appropriate, but very different from just breaking a rule in a code of conduct. One theme I feel strongly about is showing respect for people who run for council. The motivation for the vast majority is public service and giving back to their community with little compensation. I always say, imagine giving your phone number to several thousand people and telling them, if you have a problem, call me. I wouldn't do that. I mean, that's a major occupation, in my view. I think we need to be very cautious in increasing the regulations that apply to members of council. There have been municipal integrity commissioners in Ontario for 17 years. And what have we found? No brown bags full of money, no major bribes, a few who are on a power trip and think that staff must take direction from them alone. The other offenders are just confused by a very complicated regime. These are well-meaning people and should be respected and supported, in my view. Now, in conclusion, I do have a couple of suggested tweaks to the system, but they are just tweaks. Firstly, we should remove local board members from the code to encourage volunteering. We can count on one hand the number of valid complaints to date against members of local boards who are not members of council. In my opinion, councils are effectively controlling these volunteer boards. They have the ability to remove them from the boards, and I think that's all that's needed. The second tweak, the lack of jurisdiction over staff is vital in a trusting relationship that commissioners establish with staff. That doesn't happen with an ombudsman. Of course, an ombudsman can deal with a complaint against both staff and members of council. I have never filed a proposal to serve as both integrity commissioner and municipal ombudsman, and consideration might be given to prohibiting that combination. That's a little tweak that I think might be appropriate. Hillary, those are my comments. I guess we're going to hold the questions until the end, but I've been within my 10-15 minutes, and thank you for the opportunity to present.
Thank you very much. You definitely have been in within time. So thank you, Robert Swayze. Now we're going to hear from Melinda Monroe. Melinda, are you there?
Yeah, thank you. I was wondering if you were going to unmute me, if I was unmuted.
Okay, great. Thanks.
And we thank you, everyone. Thanks, Bob, for your comments, and thank you for inviting me to be part of this panel today. I'm the IC for a small municipality, and I know often in Ontario we wind up making rules, provincial rules, because we're addressing issues that happen in big municipalities. Small municipalities have some different kinds of issues, and what I want to do with my comments today is situate this inquiry in the context of the small municipality, in the context of what municipal councils are called to do in general. So I represent, as say, the small municipality, and in my consulting work, I've worked with municipal councils that are so small that they meet in the council chambers, which is actually off the side of an arena. So that's the kind of, outside of the big cities, outside of the GTA, that's the kind of context in which we're thinking about these political ethics. And the other thing I wanted to include in my comments is thinking about the difference between the role that council plays when it's acting in its deliberative capacity and when it's acting in its disciplinary capacity, which is really where we get to with the Municipal Codes of Conduct. So people run for election in order to have influence over decisions in their community. And some of them run because they're genuinely interested in politics and maybe they want to be an MP one day. Others run because they're interested in they're on a power trip, as Bob mentioned. And then there's a few that run because some issue got them very interested. Maybe there's a zoning issue in their neighborhood. But as we know about political contests, that running for election is not a job interview, it's a popularity contest. And so municipal councillors aren't chosen because they're smart or ethical or have expertise or get along well with others. They're chosen because they got the most people into the room that had the ballot box in it. And that's why they got into their role. And once they're there, they have this experience of drinking from a fire hose, where they have a very fast and hard education in everything from zoning to waste management to social services to transportation to parliamentary procedure to their procedural bylaw and to being a major employer. In some communities, the biggest employer in their community or the most important one. There's no sector like it, in my view, where the elected leadership is so close to the management of such a complex organization. And almost none of them outside the major cities have any personal staff, any admin staff, any political staff to help them understand what they're doing, to help them figure out the forms, to help them know what a proper financial disclosure is. So the Municipal Act creates this role of integrity commissioner to kind of help the councillors to navigate the complexity of what they do. And some of my colleagues in the role see themselves as coach as much as investigator or enforcement officer. And so we help them to understand these exigencies of dealing with this diverse matrix of people. They've got to talk to engineers and social workers and lifeguards and put that all together with the exigencies of trying to get reelected 4 years from now. So what we're asking is whether the current model needs to be improved to help them do that better. And so I once wrote an article for a law journal, which I entitled, "You Can't Legislate Good Faith." And I think that's what we're talking about here. Either you're going to be the sort of person where a code of conduct is just built into your bones, or you're capable of learning something new, or you're just a jerk. And the code of conduct has to kind of address all of those situations. So in trying to enforce the compliance with the code of conduct, we're balancing a couple of important principles. The desire, and in some cases obligation, for politicians to have good behavior, and the democratic right of people to elect who they wanted to. And we have the tools we use to balance those things are parliamentary procedure and practice, so procedural bylaws, the rules of procedure in the Municipal Act, precedent from other sources. Legislative mandates like the Health and Safety Act, which is part of this issue we're discussing, is protecting the employees from these kind of non-employment actors in the form of politicians, and codes of conduct, which are mandated, but the content is largely voluntary. I agree with Bob. What we don't do and what we shouldn't do is have a lot of interference from other levels of government, right? And I think as a society, we would generally believe that. We say, councillors, here are your tools, govern yourselves. So what my colleague Robert has already stated is that he thinks the current suite of resources is adequate. And I somewhat agree, but I think there needs to be protection for staff from harassment. I don't agree with him that the protections for staff from harassment by councillors are adequate. The issue is trying to figure out, is it the IC? We have a lot of skills, but are we truly skilled at investigating workplace harassment, which is kind of a unique animal? And what supports are there to support the councillors in their disciplinary role? So this is kind of where I want to go with this next. I think, my views, it's right and good that councillors discipline their own on the recommendation of a dispassionate third party like an integrity commissioner. We do the investigation, we say, here's all the background, here's the precedents, here's what is appropriate. We recommend that this is the penalty that you should impose in order to gain the outcome that you want. The trouble happens, in my view, is when the councillors don't understand that they've taken their deliberative hat off, they've taken their I'm getting elected in 4 years hat off, and they say, I've got my disciplinary hat on now. I've moved from a political analysis to a regulatory analysis. And these little councils, like the ones I have, they don't always have their own staff solicitor or a clerk who's got the wealth of experience of someone like Jeff Abrams or the clerks we see in big cities to help them understand the shift that's occurred between the political deliberative to the regulatory disciplinary. So then they turn to us, the integrity commissioners, and they sometimes ask us questions that we're not really in a position to answer in terms of how to manage their own procedural issues. And so they wind up falling back on what they know, which is politics, and the politics start to enter into the discussion about the appropriateness of the discipline that's being recommended. So in a case that I handled, a matter that I handled, the initial code breach was bad. I mean, it was racist comments on social media, and I went through and I found out, determined a penalty that seemed appropriate compared to how the same breach might be treated if it was in another context. And it was a pretty small suspension, 2-day suspension. In a small municipality, that amounts to less than $100. It's not going to hurt that. It's a much more serious penalty if a 2-day suspension for a councillor from Toronto than it is a councillor from the county of Brandon. But what else happened in that situation was the councillor had tampered with and destroyed evidence and lied to me under oath. So I recommended a 30-day suspension for that because it undermined the very basis of the ethical regime in the community. Councillors had no idea what to do with that. And I tried to assist. The councillor himself had legal counsel who was stirring up the situation. And they really struggled to think, why was the violation of the procedures in the Code of Conduct worse than being a jerk to a member of the public? And so they declined the recommendation on the procedural stuff, and they gave the guy the 2-day suspension for the racist stuff. And in another matter where my recommendation was merely that the councillor apologized, I was accused of being too harsh. He didn't really mean it. He's a nice guy, and the public liked him. So they fall back on what they know, which was how to be political. And we don't necessarily provide them, or perhaps maybe I don't, enough support to know when you're being disciplinary, you have a different hat on and a different analysis. And that is somewhere where perhaps these codes of conduct could be helpful. I'll just refer to one of my colleague Bob's current situations that he's in, actually, because it's happening just down the road from me. This councillor has been accused of racism. You probably all heard about it. It's been in the news. He loves the fact that he's been complained about. He loves the fact that the integrity commissioner just disciplined for him, or recommended discipline. He loves it. And his colleagues are stuck with weighing the local politics of being seen as a supporter or detractor of this guy because his base want him to tear down the ethics regime. So, and most of us can tell stories about that kind of weaponization of codes of conduct. So I think if we're looking at the way that we amend the regime, what we need to do is think about how we can support them in their disciplinary role rather than take it away. So rather than take it away and give it to the Minister of Municipal Affairs or to a court, we actually need to say to the councillors, we've given you this authority because we have dignified you with the right to manage the matters within your community. And we're not going to take that dignity away from you by saying that dad can spank you when there's a problem. We trust you to be able to know how to discipline yourselves and maintain order in your own chamber and then your own relationships with one another. We just need to be in a position to figure out how do we create a code of conduct, or how do we create a regime that supports them to know that's what they're doing, and to execute that duty of self-discipline. So that's me.
Thank you so much, Melinda Monroe. That is exactly 10 minutes. Okay. Next, we have Suzanne Craig. And Suzanne's bio is in the chat. So I will hand it over to you.
Thanks, Hillary. Good morning, everyone. Ian, thank you very much for putting this symposium together. It's my pleasure to be here with all of you, and Melinda and Bob. Tough acts to follow. I'll give it a try. I am the IC for the City of Vaughan and several small municipalities, and like my colleagues, there's a vast difference between who runs for office in large municipalities and who deliberates matters in large municipalities and smaller municipalities. Significant for both, but there's a different way of doing business. So ensuring accountability and transparency is one of the roles of council under Section 224 of the Municipal Act. And it is a priority for maintaining public trust. So councillors are accountable to the public as elected officials. However, it is also important that there are procedures and policies that govern those behaviors, and the Code of Conduct is a principal example. And so we're asked in the consultation to look at what changes may be needed to enhance accountability of elected officials when their conduct runs afoul of codes of conduct, how to more effectively enforce these codes, and whether stronger penalties and ethical lapses, stronger penalties are needed for these ethical lapses. And I guess I'm going to be looking at, will increased penalties, financial or otherwise, suspension, encourage the compliance of elected officials? Several code complaint investigations that I've conducted have involved significant issues around members involving themselves in the area carved out by the CAO, the city manager, senior executives of the organization. As set out by Justice Bellamy in the MFP inquiry and Justice Cunningham in the Mississauga inquiry, and more recently, as Commissioner Wake pointed out, Justice Morocco in the Collingwood inquiry, good governance is properly facilitated by clear delineation between the members of council, their roles, their oversight function in the municipality, and the role of professional staff. While most codes have provisions that require members of council and local boards to recognize staff serve council through work of the municipal organization under the direction of the CAO or the city manager, and while in an effort to underscore this division of roles, one of the amendments to the Municipal Act in 2019 was to require that all municipalities adopt and maintain a policy regarding the relationship between members of council and staff. The question continues to be, do the current penalties afforded under Part 5.1 of the Act work to promote productive and respectful interaction relationships between members of council and the staff that serve the municipality? In the Collingwood inquiry, Justice Morocco put before us a concerning picture of the circumstance facing the CAO of the town vis-a-vis their relationship with members of council. I'm going to quote what he said. It was apparent in the matters I examined in Part 1 and 2 of the inquiry that the importance of the CAO in the proper functioning of the town was not appreciated. This lack of appreciation manifested itself in a manner that the role was treated publicly and in the approach to the role taken behind closed doors. This failure, remarked Justice Morocco, weakened the key pillar in the structure of the municipality, contributed to the blurring of the boundary between council and staff, and made it easier to avoid proper procedure in the pursuit of council goals. Justice Morocco has identified what Justice Bellamy identified, which was identified by Justice Cunningham, which was identified by Justice Oliphant. Without foundational rules and respect for statutory roles and the separation between staff, the operation, and council, the oversight, there's no municipal governance. There are wide gaps that allow for undue influence and abuse of power. In one of my code investigation reports to the City of Vaughan in 2015 with respect to the conduct of former deputy mayor, I said that I recognize that elected officials come to their position with diverse interests, personal perspectives, political support from business and community. That's great. In fact, this spectrum of knowledge, I pointed out, and I think we all agree, make them and coming together as a body so crucial for the strength of the community. However, in that 2015 code complaint investigation, and also in the code investigation of another elected official, a mayor, a former mayor, and his bathroom manifesto wall, I determined that when a member of council acts in such a way as to afford preferential treatment to one group over another, make harsh comments against staff, attempt to use their authority for the purpose of commanding, unduly influencing, and intimidating with the intent of interfering with staff's duties, whether they understand the rules or not, including the duty of staff to disclose improper activity, the municipality risks having a poisoned workplace. The answer may lie, I submit, in a more unified approach across municipalities in Ontario to what minimum standards are included in codes, and more importantly, code protocols, those policies that set out how we will investigate. I think there is a need for the marriage of clear and detailed staff council protocol provisions with a code complaint protocol that sets out the type of remedial action that the IC can recommend to council, and you know, whether or not the penalties are strong enough to act as a deterrent to the member of council. Because as Melinda has pointed out, some members of council are absolutely fine with being reprimanded and receiving a suspension of pay, because that really stirs up the people who say you're doing the right thing. As Bob Swayze, Commissioner Swayze, and I have lived uncomfortably being walked into a council chamber by police officers as you face an angry mob, as you bring your report to council, is not something that should happen, but it does happen to integrity commissioners. What I want to touch on very briefly before I close is the importance of the contents of a code protocol and the requirement of having, in my view, and many of my colleagues' view, a code reg that stipulates minimum requirements for complaint procedures. For example, giving advance notice to the respondent of adverse findings, making the respondent having to reply and cooperate with the integrity commissioner as required. We've seen, I certainly have seen, and also in some of the ongoing investigations, that a respondent can just choose not to reply to the integrity commissioner and not participate in their investigation, and then a judicial review can purport to have been denied procedural fairness. At the City of Vaughan in 2015 code complaint investigation, as I mentioned, and at the town of Witchard-Stouffville, the issue was and is requiring a member named in a code complaint to participate. And oftentimes when we make recommendations to council, council says things like, well, did they get an opportunity to speak to you? Did you hear their side of the story? Was it a fair investigation? Well, all of us know that it usually is, but what is not in any of the regs is the requirement of a member of council who is named as a respondent in a code complaint to participate and cooperate with the integrity commissioner. I'm just going to close by saying that the province's consideration of increased financial penalties or a prescribed set amount as a monetary penalty in respect of a finding of a code contravention, as opposed to a quantum equal to a set number of days of their remuneration. This may make sense in some of the smaller municipalities where a monetary penalty in proportion to their small stipend doesn't serve as a deterrent. However, given the disparate size of municipalities, landing on a common monetary range would be difficult. Just in the interest of time, I'm going to just close with two statements, two of the recommendations from the Bellamy inquiry. I've had this for I don't know how many years, and I go back to it all the time, because really this is what I say to members of council and staff alike. In the section dedicated to complaints, investigation, and Justice Bellamy says, the city should give integrity commissioners the power to recommend to council an appropriate range of sanctions for ethical misdeeds by staff. They should be closely modeled on sanctions allowable under prevailing labor and employment law. And under education and outreach, Justice Bellamy recommended the integrity commissioner should have the mandate and resources to participate actively in the development of ongoing educational programs or materials for city staff. So ensure that the staff council protocol is tight and everyone understands the division of roles between staff and members of council. Ensure that the code protocol sets out the procedure that the integrity commissioner will follow in her investigation. Require the respondent to participate with the integrity commissioner, and ensure that the integrity commissioner is given the duty and the mandate to educate both staff and council. I'll turn it back to you, Lori.
Thank you so much. Exactly on time. Powerful comments from everyone so far on the panel. Thank you so much. We'll now turn to our final panelist for this morning's session, Jonathan Batty. Jonathan?
Thank you, Hillary. So Commissioner Wake is quite right. This is the third time in the space of about 2 weeks that I've appeared with him in some form on a panel talking about integrity issues. While this is the third time, perhaps third time is a charm, and certainly last but not least. With that being said, I don't think it's an accident that this is the third time in recent weeks I've been speaking to these issues, because I think there are serious issues that are before the province right now. And I'd like to thank Professor Stedman for his invitation to join this panel today. I'll be focusing on one particular thing, and I'm going to be focusing on allegations of harassment involving elected officials. I think Ontario has a really important question before it. In the city of Ottawa and the city of Brampton, 2 councillors have recently been found by an integrity commissioner to have contravened their respective codes of conduct. The integrity commissioner's investigations concerned allegations of sexual harassment, and the dispositions by council are now subject to litigation before the divisional court. Ottawa City Council and Brampton City Council, in deciding these matters, each asked if the penalties at their disposal were adequate to remedy the situation. We need to consider, therefore, how allegations of harassment against councillors should be investigated and decided. Because of the consultations the provincial government announced in March, and a private member's bill, Bill 260, before the Legislative Assembly, this question is now the subject of public debate. Ontario is searching for a legislative solution. I am not sure I have that solution today, but I do have some thoughts about the policy questions that need to be considered to design one. It is, I believe, a shortcoming of our municipal accountability frameworks that the anti-harassment and discrimination prohibitions that are afforded in provincial workplaces are not effectively applied to elected officials. That gap may be the product of a halcyon view that elected officials occupy a unique role, and if found to have engaged in serious unethical behaviors, will, quote, do the honorable thing, close quote, and resign before being held to account at the ballot box. Let me say a word about anti-harassment and discrimination protections in the workplace. Ontario's Human Rights Code includes protections against harassment and discrimination in the workplace. They are dealt with in an adjudicative process by a tribunal with comprehensive remedial powers. But I am not aware of those powers being tested in relation to a workplace harassment complaint against a councillor and that person being subject to any disciplinary measures. Additionally, the Occupational Health and Safety Act was amended almost 11 years ago to this day to require all employers in Ontario to adopt proactive policies addressing harassment in their workplaces. Conversely, employees were extended the right to refuse work if they are subject to the threat of violence and harassment, if their employers do not adequately assess and mitigate the risks they face. Anti-harassment policies are not comprehensively applied to councils or their members. Ontario's municipal councils are not unique or alone in needing to address these issues. As a result of the Me Too movement, legislative bodies across North America are being called upon to address this issue. In the last few years in Canada, Equal Voice assessed how the House of Commons and our provincial legislatures measure up. In its paper, Best Practices for a Harassment Policy for Elected Officials, Equal Voice noted that Parliament and many provincial legislatures did not have clear and effective policies for addressing workplace harassment. Why is that? This leads to the second thing that we need to consider: the unique role of elected officials, which in our case is the unique role of councillors. Councillors differ from MPPs and MPs in some significant ways. They do not sit in a constitutionally recognized elected body, like the House of Commons or the Ontario Legislative Assembly. In many ways, they are not self-regulating. They do not have an inherent constitutional power, for example, to expel someone from their elected body. Their powers are defined by provincial legislation, which can be amended without prior notice or approval. They do not sit in caucuses of political parties that are formally recognized and organized in their legislative body. However, they may have more daily interactions with senior city staff than the average MP and MPP has with senior federal and provincial public servants. Arguably, they are comparatively better known within the city's bureaucracy and more influential within city government than their average counterparts at Queen's Park and in Ottawa. But councillors and MPPs and MPs share some overriding similarities. They are all entrusted with the authority to make laws governing our activities. In office, they are expected to represent the best interests of the community and their constituents. They serve as stewards of the public's trust. They are asked to meet the highest ethical standards because when they fail to do so, it is a breach of that trust. Ultimately, they are accountable at the ballot box. Increasingly, however, it is recognized that accountability at the ballot box may not be the single best way to hold elected officials, in our case, councillors, to account. Why is this? One reason may be that the terms of office have lengthened and the power of incumbency when running for office is very powerful. There are also circumstances where the province has decided that some conduct warrants removal from office. We had a recent example in Toronto of a councillor being removed from office for failing to comply with Municipal Elections Act requirements. Another example is where, under the Municipal Conflict of Interest Act, a judge may declare a member's council seat vacant, order financial restitution, suspend pay, or order a reprimand for a member who acts improperly by furthering their own pecuniary interests. Lastly, a council, upon the report of an integrity commissioner, may reprimand or suspend pay for breaching a code of conduct. While comprehensive anti-harassment policies apply to every other provincially regulated workplace, the natural question that follows is, why aren't councillors, as elected officials, subject to the same sorts of obligations and sanctions? In the recent cases in Ottawa and Brampton, councils question why a councillor found to have engaged in egregious harassing behavior could not be dismissed, as would any other person in the workplace. It is a question we all have, and is a question the provincial government is asking us all to consider. In one respect, the answer is simple. There is no legislative provision that specifically requires this. All employers, including municipalities, since 2010 have had to adopt specific policies addressing harassment in their workplaces. While many municipalities have incorporated those policies into their codes of conduct, the progressive discipline regimes in those policies have not been legislated by the province, as they would need to be to apply to councillors. Which leads to the basic question in 2021. Why not? Holding elected office is a unique privilege, but elected bodies are not immune from the problems of harassment experienced in other workplaces. Surely, if mistaken election finance reporting or financial self-dealing are considered grounds for removal from office, why isn't harassment? They are all self-serving and unethical behaviors which directly harm others and irreparably destroy the public's trust in an elected representative. So, I return to the question I asked at the outset. How should allegations of harassment against councillors be investigated and decided? To my mind, there are 7 significant policy questions that need to be considered when designing a legislative solution. First, should councillors have mandatory training about anti-harassment requirements in the workplace? Given the influence and power that councillors exercise within city government, should they be required before assuming office to receive the same sort of training and certification that city managers and employees do? Secondly, should there be a duty to report misconduct? This question has a couple of dimensions. Should elected officials have a mandatory duty to report instances where they learn that another elected official has harassed someone? Conversely, should city managers and employees have a mandatory duty to report instances where they learn that an elected official has harassed someone? I ask this because a culture of silence and denial in the workplace is wholly detrimental to eliminating inappropriate behavior. Thirdly, what range of penalties are appropriate to impose? While it may be straightforward to issue reprimands or suspend pay for misconduct as it is for employees, a range of other progressive disciplinary measures, short of termination, may not be practical or advisable. Councillors, unlike MPPs and MPs, are not subject to the internal party discipline of a caucus. because councillors are elected, unlike people who are hired or appointed, suspending them from serving on council or committees or dealing with constituents has adverse consequences for others. I am concerned that some valid employment law remedies imposed on a councillor, like a temporary suspension from office or removal from committee, could adversely affect constituents, council, and the good governance of a municipality. I would never suggest that someone not be penalized for inappropriate conduct. But perhaps we need to consider that because elected officials occupy a uniquely powerful position of public trust, a serious breach of that trust can only be remedied by removal from office. Fourthly, what remedial measures should be available? What supports should complainants receive, and how should they be involved in this process? Imposing penalties on those who harass others is an important part, but not the only part of an effective system for addressing these matters. A comprehensive solution and a range of remedial measures may be needed to correct a poisoned situation. If a culture of silence and denial is to be eliminated, complainants must be appropriately heard and supported in this process. I think the province needs to hear from concerned members of the public and experts in this field about what needs to be put in place. Fifthly, what supports and indemnification should councillors receive, and how should they be involved? We need to recognize that holding elected office is challenging. We ask a lot from those whom we elect, as we should. But any process that formally questions someone's conduct and capacity to hold office must be imbued with fairness and permit them to full answer and defense. Like complainants, they must be appropriately heard and supported in this process. Again, I think the province needs to welcome input from the public and experts on those issues. Sixthly, if that's a word, who is best placed to investigate these matters? When allegations of harassment and discrimination are investigated, we need to decide how to do this in a fair, expert, and impartial manner. Whoever investigates these matters needs to be independent from council and have the required expertise to investigate such matters, or have the ability to retain expert investigators who do. I think it incumbent on the province, if it is going to adopt such a requirement for municipalities, that it also fund that process. And lastly, my seventh point, who is best placed to impose penalties? In asking this question, I would recommend that the province adopt a model where the person or agency mandated to investigate allegations of harassment is not the person or agency who adjudicates the questions, and where misconduct is found, orders the necessary penalties and remedies. I also think that it's wrong to view such matters as political questions that require political direction or a political solution. To the greatest extent possible, I think politics needs to be taken out of this process. I recommend this because there is a danger that where allegations of harassment are debated and decided in a political forum, irrelevant issues are raised and debated to the detriment of the complainants, the respondents, and the legitimacy of the process itself. An expert, transparent, and arm's length decision maker needs to decide whether the results of an investigation warrant dismissal or the imposition of penalties and remedial measures. Whether a special purpose body is created to do this work or it is assigned to an existing one, it needs to be a fair, timely, and efficient way of reaching a final decision and be able to take the politics out of the matter. In closing, I would also add that the considerations and questions I have raised for municipal councils could well be considered for Queen's Park and for Ottawa, but that's a question for another symposium. Thank you for inviting me to speak. I look forward to your questions.
Thank you so much, Jonathan Beatty. You made it within the 10 to 15 mark. But to give some time back to the other panelists, I'm going to actually ask the three folks who went before you, do you have any responses to the other panelists to kind of continue this? We have 3 questions waiting from the participants, but I'd like to hear your thoughts.
Lori, it's Bob Swayze. I just want to deal with applying employment law to elected officials. It seems to me that all of that depends upon who can remove an elected official from council or anywhere else for that matter. I believe that only a court can do that. We have a very diverse group of integrity commissioners, but I don't think any of them should be empowered to remove a councillor from council. And when I was in Mississauga, I was 5 years in Mississauga, beginning with 2012. And I was asked early on, I was asked by the Director of Human Resources to please take over any kind of HR responsibilities for members of council. The approach by employment lawyers, the approach by employment consultants, all depends on they have the ultimate right to fire a person. So I'm sorry, Jonathan, but I don't agree with your position on applying employment law to elected officials. Thanks.
I just have one comment. You know, we look at the comment that Commissioner Batty made about the recently unseated member of council for the City of Toronto. And I'm not an expert in the Municipal Elections Act, but we do know that there's sort of a quantum of campaign spending. It's a calculation. The evidence is brought before the courts and it's yay or nay. I have some concern that the 2 vehicles we currently have for electing representatives of the public, the ballot box and the courts, have found a continuous re-election of bad players, and the courts loathe to exercise their discretionary authority to remove. So while I don't disagree with my colleague, I'm concerned that stepping into that role where those who have that role have been timid in exercising it is a concern.
Yeah, I think I'm gonna sort of agree with everybody there, but I'm really grateful for Jonathan's comments, and I was wanting to cheer for him as he was speaking, because while I agree with Bob that the right of removal of a councillor is one that we have to consider very carefully within the balance of wanting them to behave well and wanting to elect who we want to elect, that we have to remember the rights of the employees and their right to be protected and to be kept safe from people who can interfere with them in their daily ability to do their work, disparage their professional reputations in front of television cameras, who can sexually harass them, as we have seen coming out of Ottawa. They have a right to be protected from that environment. And the CAO has this job that's almost untenable if there's no mechanism by which you can impose any sort of legitimate penalty on a councillor that's meaningful. You know, the $50 fine, like a 30-day suspension for some municipal councillors is like less than $1,000. That's not enough. That's not enough of a deterrent from the penalty perspective, and even from the being found guilty perspective, it's not enough to protect those employees. And speaking, I'm going to say there's a gender and a race-based element involved in this stuff that has to be considered. That it's women and it's people of color and Indigenous people who are going to bear the brunt of not dealing with harassment by councillors.
Okay,
I was going
great.
to, I was going to
Oh, jump on
for a
in.
moment. So, to clarify, I agree with Bob entirely. I do not think integrity commissioners should be making the decision to remove somebody from office. I think how this role was envisioned at the City of Toronto and through other municipalities is that an important component of this job is to provide support and advice to councillors. It's increasingly becoming very, very litigious, but as I was describing my model, I think the adjudicative function needs to be absolutely separate from the investigative function. I think that's absolutely crucial, and I agree with Bob entirely on that point.
As moderator, I just want to make some observations, drawing on some of my experience with the Canadian Business Ethics Research Network, working in like corporate social responsibility for over a decade. And often people talk about codes of conduct as the instrument by which we will find remedy, or we will find remedy to the situation. But one of the things about codes and education and culture is that often they are enabled or disabled through organizational structures in business. So there's three main ones. One is what are the monetary and non-monetary incentives for behavior? What's the performance evaluation management and controls? And what is the partitioning of rights and responsibility around decision-making and jobs? And it sounds like, just to kind of transpose some of that onto this situation, which is very unique in terms of municipal governance, that a lot of what we're seem to be landing on is that performance evaluation, management, and control piece. And what I hear you saying, Jonathan, is that role, people are uncomfortable with that role being like an integrity commissioner piece, but it doesn't mean that it isn't part of the structure of a situation around which, you know, a remedy can be found. So hopefully in our second panel around solutions, we can circle back to that and see like how this can be solved. Garrett, I'm just going to turn this over to you in the questions that we're getting from our participants in the chat.
Okay, thank you, Hillary. So I have a question here that sort of speaks directly to the point that was just made about using the courts. Going to court is prohibitively expensive if you are seeking the removal of a councillor. Do the speakers see that as an access to justice issue? Why or why not?
I'm not sure who you're directing the question to, but
the question was to the panel. So
okay, well, obviously that's almost prohibitive when going to court, and that's why in Bill 86 the decision was made to give the authority to the integrity commissioner to take a matter to court, and municipality has to pay for it. They've got deep pockets, and I think the integrity commissioner considers the seriousness of what the offense is and also the cost. But you're right, the cost of going to court is prohibitive.
If I could jump in to Melinda's point and to the imbalance of adverse consequences to women and racialized groups, I do believe that the core function of an integrity commissioner remains education. And I think that one of the areas where we tend to not put most of our efforts is that information and education and outreach piece. I actually participate in town hall meetings, and I go out to the community and speak to the community as integrity commissioner. And I think one of the things that we see is that all of us have different contracts, and it would be, you know, we don't want to have too much meddling in our contracts, but I think it's really important to stress the education component, and an integrity commissioner should not be prohibited from going and speaking to the public to let them know how they can hold their elected officials to account. And one of the ways that I think we can bridge that gap of access to justice and access to information is being that conduit to the community, not only informing members of council what their roles and responsibilities are, but empowering the public to understand that this is what you can do. This is what the code investigation process looks like. Yes, you can go to court, but this is how I can bring forward a change in the behavior of members of council. And then interacting as a former integrity commissioner, Lieber, looking at integrity by design throughout the entire organization and trying to see how the integrity commissioner and her understanding of some of the ethical lapses of members of council as it bridges harassment and discrimination can be addressed through other areas of the city. I don't think I answered your question, but those are my comments.
So I'll jump in.
Great.
I definitely think it's an access to justice issue. And that's why I allude to it in the points I make in terms of support and indemnification for the parties. Councillors have all range of financial resources behind them. Some may have a lot of personal financial wealth, others may not, and their income is, in the case of the city of Toronto, for example, just their councillor's salary, and defending anything in court is very expensive, and I am concerned about not only access to justice, but equal and effective representation, because I think he may not have said it explicitly, but implicitly, I think we have to be very careful in all of these things, not making the requirements of public office so onerous that nobody wants to, or is in fact able to put their name forward. So that's why I think in all of these things, we need to very carefully consider the supports, and in some ways the legal advice and the actual financial support of people who end up being required to participate in this process.
Melinda, what are your comments? What are your thoughts on this?
I was just, thinking they all said such great things. But I think Jonathan, makes a good point about when people have access to justice, it's kind of two-sided. As Bob mentioned, ordinarily the council is going to pay for the integrity commissioner to bring the case to court. The integrity commissioner is not going to pay for that. The public don't have a lot of rights in terms of being able to bring a councillor to court. And so it's not that some member of the public or a member of staff. Having said that, a member of staff might, bring in and bring a wrongful dismissal or bring some kind of an action against the municipality because of behavior of a councillor, and that's an access to justice issue for them. But I think the issue is really the right to a fair defense, so that the councillor who's being asked to be removed has the ability to actually defend themselves in that proceeding, and they. In situations where it's simply been a matter of me making a report to council for a minor suspension of a few $100s. Councillors have spent thousands and thousands of dollars on their own legal counsel to defend themselves against whatever recommendation I might ultimately make. So councillors that don't have access to a lot of money, that it does make it very hard for them to defend themselves.
I have a follow-up from the room, Hillary, to that.
ahead.
So the question is, should councillors be able to fundraise in order to obtain legal counsel?
I'll jump in. Recently at one of the municipalities, I'm not going to say, but you can certainly search Google. One of the municipalities wrangled with the indemnification bylaw of the municipality. And I can say that because that was often the case, it wasn't so much a GoFundMe, it was a developer come help me. The indemnification bylaw actually put in provisions that would require a member of council to identify if they are seeking outside fundraising opportunities, and that was prohibited. I think we have to be very careful. I've had another jurisdiction where a member of council, wanted to go to judicial review, disagreeing with one of my decisions, and did decide to put a GoFundMe. And I actually said that you're influencing and certainly denigrating my decision. So I do have one instance where the indemnification bylaw specifically prohibited a member of council from doing that. It was challenged, but it was included in the.
Maybe I should jump in. That's a very good question, and I've never ever considered it. Is it appropriate for a councillor to fundraise to fight something in court related, obviously, to the municipality? I think not. I think that that's a bit much. On the other hand, there are, as Suzanne says, there are indemnification bylaws that are appropriate, and most of them require the councillor to pay if they're not successful in court. But that's a very good question, Garrett.
Linda, just circling back to one of the things that you talked about in terms of influence in small municipalities and how that is actually a very different kind of context within which some of this operates. How do you see any differences in the way that this can play out?
You mean in terms of this issue of fundraising for legal fees?
Yeah.
It's a tricky question, isn't it? Because we think it's very important to manage the way councillors are using their influence. And the Municipal Elections Act has rules about fundraising and reporting donations. The Municipal Conflict of Interest Act is going to create a problem. So if the councillor is suppose the councillor is trying to raise money for a judicial review and they get a donation from a big developer, now they're recusing themselves from sitting in on decisions involving that developer at city council. And in a small community, so again, you have this issue of people in the small community who may or may not have a lot of money, trying to defend themselves. And I'm not going to say that all my integrity commissioner friends and colleagues make the right decisions every single time. I don't make the right decisions every single time. And sometimes those JRs are appropriate. And then we need the courts to periodically weigh in order to create, some scaffolding around the role. And so I'm not going to say it's a bad thing every single time for someone to say, I'm taking you to a JR. But how do you make sure that the councillor who needs to do that is able to do so in a way that's fair and appropriate? And I think perhaps Suzanne has the right idea, is that the indemnification bylaw ought to provide for a councillor to be indemnified if their JR is successful. It still creates a problem. How do they get enough money? How do they get the $20,000 or $30,000 to get themselves to divisional court, particularly if the integrity commissioner is fighting back hard? I don't know. It's a good question. But in small municipalities, they're not getting paid a whole lot of money to be there. So there's more danger that they're going to behave badly in some ways because they don't have anybody to help them. Because and on the other hand, where do they get the support to actually take on some of these really big questions? Because the question of constitutionality, the question of authority, all those questions are the same question whether you're asking them of the mayor of Toronto, who's got every support in the world, and the mayor of Bugsplat, Ontario, who has none. Same constitutional problems arise. Same bad law is going to emerge if there's not a way to help them.
I think the funding question, I think the remarks are really well taken. One of the concerns I would have about, for instance, a GoFundMe campaign, for instance, for a JR is whether, and it's a question that I raise, I don't know that I definitely have the answer right now, is actually if it would itself be prohibited because it would be soliciting gifts from people. But I'm going to sneak in a question for Suzanne in my remark, and it has to do with the question, because I think it relates to AMPs, administrative monetary penalties. Because if we move to a system where we have AMPs, I think this issue is really going to come to the fore. And I guess I just wonder about those instances where you have someone who may not really care at all about certain provisions in the code and want to make a point of bucking those rulings. How do you avoid AMPs becoming sort of just like the cost of doing business, which you then cover through a GoFundMe campaign for your supporters? So that's a pretty big question.
Right. Well, so I think my position is that and it gets back to what Melinda said at the beginning of her presentation. You know, can we legislate? I don't know what her exact words were. Can we legislate good faith? And more importantly, can we fine a bad actor into compliance and avoidance of ethical lapses? I don't think we can. Whether it is the city of Vaughan, where a 90-day suspension of pay is a significant amount of money, or whether it is the township of, somewhere in Northern Ontario, where a suspension of pay, even if you have concurrent lapses, and it becomes, 6 months. I don't know that is going to get us to where we want to be, and it would be a nightmare for the bureaucracy to find a formula that would, relate to, how they would fine. Would the province suggest that there is one fine fits all? Would it be again some proportion to the remuneration? So I actually feel that that the fining and the monetary penalties is both a burden to the municipality, not a deterrent to the member of council, and pretty much becomes mundane after the fact. I actually think, and years ago, someone said to me, well, so is your power to shame? And I think I would not use the word shame, but I think it is holding up a mirror to the member of council. And I would say that it is in the strength of the ability to publicly announce the wrongdoing, and together with perhaps a heftier monetary burden, just to assist the city or the municipality in getting some money back into their coffers might be a good way to go.
Okay, thank you all. I'm going to move on to our next question, and hopefully we'll keep circling back to these.
Yeah, so we're the next two questions I'm going to put together. They sort of change tone a little bit. So here's the first question, and then I'll just follow up with the second. Should there be mandatory information sessions for newly elected councillors, including incumbents, about the rule of law, need to administer municipal laws impartially, and the ethics rules? And can you say more about the Integrity Commissioner's role in training and education to prevent problems as opposed to the regulatory remedial role? So I think those two go together.
Well,
Who wants to start?
I don't hear anybody else, so yes, I think, Garrett, the answer is obviously yes. I think that the initiation, the councillor, the education, it could be mandatory as far as I'm concerned. And it should include the integrity commissioner and there are other very competent consultants in the field that should be employed. And I've done a lot of it. It's very valuable because some councillors come in and they have no concept of what they're getting into. So I support that.
I'll follow up on Bob. I do as well. And so in my non-integrity commissioner work, I do a lot of work on municipal organizational stuff. And we do spend a lot of time with councillors, and councillors are running and they're getting elected because they want to have an influence on road design, or they want to have an influence on some other task or service that the municipality delivers. And you know, rightly so. I mean, this is part of their governing role. But I'm not sure that we spend enough time. So when they get oriented, they have like day-long sessions where the city engineer tells them all about how roads are done, and then the city social services director tells them all about Ontario Works. And but what they really need to know more of is what Suzanne talked about, the council staff relationship, the protocols about that, and how their obligations as a deliberative body, and their obligations, as we've talked about, as a disciplinary body, and how they function as a council. So it's not as important, in my view, that they know as much about how we decide whether we're going to, you know, put a sidewalk in this neighborhood versus that neighborhood. It's what's my role in how we decide that. So I'm not the city engineer, and I shouldn't be taking a day-long course in how to be that. I need to take a day-long or a month-long course in how to be a municipal councillor, and what my role is with respect to my political and my deliberative role in that relationship. So I 100% agree that should be mandatory, and they should spend some time learning about how that works. And so, you know, I've done it for the council that I work with, and I absolutely think it should be something that is built into the codes, or even built into the act as sort of one of their expectations.
I have a story that I thought of that might help with that question, because early on in the GTA, I was appointed integrity commissioner, and a new mayor was elected, and he was a senior executive, and he told me the story that he had a friend who was one of my colleagues, a municipal lawyer in Toronto. And he called him up and he said, we have to talk. We should get together. I need to know what my powers are. And this fellow whom I know didn't return his call for several days, and the mayor got all upset. Finally, he got through to him, and the lawyer said, "You don't have any power. You have one vote." And that's the message that has to get across to these people who think, I'm taking over. I've been elected. I don't agree with what staff is doing. As far as I'm concerned, they have to listen to me because I'm elected. That's the message that has to get through. And it's so important for some people, particularly in these smaller municipalities where they really try to take over. But that's my story.
I would agree with Bob. And, you know, I've had several members of council say to me, you know, I represent a base. I have been elected to represent this group, this ward. And usually in my education sessions, I say, you know, let's look at the act. There's the role of council. There's the role of, you know, the CAO. There's the role of the chief building official. Do you see the role of the individual member of council? Now, having said that, I think in our training sessions, pointing out that a member of council has no more of a vote than any other individual member of council. It is council that makes the decisions for the municipality. It is council through the CAO or city manager that directs staff, and you do not insert yourself inappropriately into the operational business of the township or city. That's fantastic. And here's what many members of council do. They go find somebody who preaches their song, and they say, let's get that person to give us training. And then what we're told as integrity commissioners is that municipal expert or that person said that this is what we can do. So I think that there is that delicate balance of requiring the governing legislation to sort of broadly touch on some of these issues, sort of reiterating through the purpose of accountability and transparency, the role of council, as opposed to there is no role of individual members of council, perhaps assisting in adding commentary. This is what a councillor can do, very similar to what the Ministry of Municipal Housing does. But let's be really clear that the strength of our education is only as much as council wanting to listen to us. So having a mandatory requirement that councillors must attend integrity commissioner sessions when they go out and get their own flavor of the month from a municipal expert is problematic. I think rule of law is where the rubber hits the road, and I think we don't want to legislate ourselves out of any sort of flexibility. But the problem is a role in clearly stating, even through an information bulletin, that there is no role for an individual member of council.
And I don't want to take up too much time with all my stories, but that's the key. The key is that council is 100% in charge, but a member of council only has one vote. Now I'll tell you a story. There was an in-camera meeting on some subject of a small municipality, not tiny, but a small municipality, where one of the councillors had some experience in HR, and he started saying, I think that we have 6 positions that are surplus. I think we should fire these 3 people and eliminate these other unfilled 3 positions. And so this came up, and I had the council table nodding, and the CIO said, whoa, wait a minute, I don't know anything about this. Let me come back to the next meeting and deal with these positions. So the next meeting, again in camera, he eloquently described how important all these positions were. So they fired him too. And that's not so bad. CAOs get fired, but they didn't intend to replace him. So I actually get a complaint saying no CAO is wrong, and so I jump in, and I was very concerned, and I talked to the staff, and of course they were 6 department heads, and they were meeting and trying to do things by agreement, and everything was going okay. And so I actually bounced it off the Municipal Integrity Commissioners of Ontario, our little association, and everybody agreed with me that you have no power. You can't do anything. Council is in charge. Now, I did say in a session, an educational session with council, I said, now if some member of council, including the mayor, had tried to attend these meetings of staff and tried to chair them or do anything like that, I would have taken action against that member of council. But that's my story. Sorry to take so much time.
We're gonna kind of circle around and close up, and then I'll hand it back to Ian. But I just wanted to, one of the things that I'm observing in the discussion is the lack of setting a floor. So one of the things that Jonathan really pointed out really clearly is that there is no floor set for performance and conduct around sexual harassment in the workplace for councillors, right? There's no floor set, doesn't sound like. And what I'm hearing now is there's no real floor set in terms of roles and rights and responsibilities of decision-making around councillors, that this is often being worked out. But there is kind of consensus around this real importance around setting a floor on mandatory education of something. So I just want to kind of get your thoughts around how might a floor be set? Because this is creating a lot of inefficiencies in Ontario government, it sounds like, right? So if there's something in perverse decision making, like if we never wanted to solve this problem, what would we keep doing? And often that's just the status quo. We would keep doing the thing that's creating the problem. So how would you solve this? How would you solve this problem?
So I actually wanted to jump in for a moment on this point, and it's flowing from the last discussion. And there's been discussion previously of the report from Associate Chief Justice Morocco in Collingwood. And there are a couple of and it's over 300 recommendations. So there's a lot in there. But there are a couple of recommendations which speak to this point. So as I recall, he has a specific recommendation that actually the role of a member of council should actually be defined in the statute, which it isn't now. So what you have currently is a provision in the Municipal Act and the companion provision in the City of Toronto Act, which talks about the role of council as a whole, as opposed to individuals. And so one of the things that he's recommended is that there actually be a specific provision about the role of a member. And tied with that, the inquiry report also recommended that actually the role of the head of the council, the mayor, be re-examined, because there's a mention in the current statute that the mayor, in fact, it serves as the CEO of the municipality. And one of the things that Justice Morocco recommended is that's actually the wrong conception, and that needs to be revisited. So I do commend that inquiry report to everyone, because some of those governance issues are actually raised in it, and I think that speaks a bit to your point, Hillary.
Other comments? Closing up?
Yeah, I just want to jump in very quickly and say that almost all of the codes of conduct at the municipal level in Ontario have a section entitled harassment or harassment and discrimination. And I think it's important to note that there is a floor, because all of our codes of conduct actually state very clearly that a member of council, the city or the town's respectful workplace harassment and discrimination policies apply to the member of council through the application of the code rules as applied by the Integrity Commission. I think our disconnect is where there is, in fact, a code of conduct complaint that arises. There's this, I don't know who's got jurisdiction between the HR people and the Integrity Commissioner, and if it comes to the Integrity Commissioner, does she, do an investigation under the policy, the workplace policy, and then apply the rules of the code? So I think what we need here, if you were to ask me, Hillary, what needs to be done is not what we're doing now, which is who's got jurisdiction. Very clearly state in the code and the workplace policies and in the Municipal Act that the Integrity Commissioner has jurisdiction to receive complaints about harassment leveled against a member of council.
Here, here.
Melinda, thoughts?
I was cheering for Jonathan again over the getting rid of the stupid CEO sections in the Municipal Act. I don't know who dreamed that up, but it is bizarre. And the municipality where I currently live, this is not to do with me as an Integrity Commissioner. On the city's website, it describes that role and it's completely wrong. And so that has to go. I think that does create a problem. But to go back to what Suzanne was saying, I think that I agree with her. That is the problem. We have this problem of the tension between who acts. And if I'm a CAO, so putting my hat on as a CAO, my anxiety about that issue is that I have obligations under the Health and Safety Act that are pretty strict. And if I'm going to hand this jurisdiction to protect my employees over to this Integrity Commissioner, I need to trust that what they do is going to make sure that I'm covered for my obligations under the Health and Safety Act. Because it doesn't matter that the harasser is the councillor, my duty to protect my employee is still the same. So I think that's where you get that tension, is that the HR directors and the CAOs are saying, well, you know, you have this role that has to do with politicians, and I'm not so sure that you have the chops to get into the serious workplace harassment stuff that I need to know I'm covered under, or else I'm facing WSIB costs, I'm facing all kinds of stuff. And so I really think that jurisdiction is really kind of special compared to the other stuff we do.
Okay, thanks so much. I'm going to hand it back over to Ian Stedman. Thanks, panelists.
What incredible timing and what an incredible start to our day, everyone. Thank you. Honestly, this has exceeded my expectations. Such a lively discussion, and there's so much for all of us to chew on. Honestly, fantastic opening half, loved it. Thank you to each of our speakers. Thank you to our chair, Hillary, and to everyone who submitted questions. What we're going to do now is take a break for lunch at 11:45, and we might actually do it at 11:45. Come back at 12:30, but if you come back about 15 minutes early at 12:15, Choice Point Solutions is going to do a demonstration of their ethics training software. I would encourage you to come back. I'll tell you that I'm teaching a course on public sector ethics, and this year we're designing some software to integrate into my course because we anticipate it will be online, and it's really innovative. So if you're interested in learning more, please come back at 12:15 before the end of the lunch break. Other than that, have a great lunch, everyone. I'm looking forward to a wonderful second half, and thank you again.